Welcome to the 11th meeting of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference for Thursday, March 31st, the committee is meeting to study Bill C5, an act to amend the Criminal Code and the Controlled Drugs and Substance Act. Today's meeting is taking place in hybrid format pursuant to House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. And I'd now like to welcome our witness, the Honourable David Lametti, Minister of Justice and Attorney General for Canada, who's appearing in person in the committee room. And I would also like to say I don't have my flashcards today, so I'm going to rely on the Minister and my colleagues to stay within time, but I will have to interject when the time is needed to let you know that your time has run out, but I ask that you stay within the time. Thank you, and over to you, Honourable Minister Lametti.
Monsieur le Président, c'est un honneur de me joindre à vous ce matin.
Mr. Chair, it's an honor to appear before the committee to speak about the important amendments on traditional lands, and I'm accompanied by François Daigle, Deputy Minister, as well as members and experts from the department. Matthew Taylor is here with me, as well as Carole Morency and Andrew DiMano. So I would like to thank everyone for being here and welcome people in person and on the screen.
This committee to speak about the important amendments proposed in Bill C5, an act to amend the Criminal Code and Controlled Drugs and Substances Act. Ce projet de loi s'inscrit dans le cadre des efforts déployés par.
This bill is part of our government's efforts to combat systemic racism and discrimination. These are realities faced by too many people who come into contact with the criminal justice system. From the first interactions with the police all the way to conviction.
5 includes 3 categories of reforms. First, it will repeal mandatory minimum penalties for all drug offenses, some firearm offenses, and 1 tobacco-related offense. Second, it will allow for greater use of conditional sentence orders, or CSOs. The third reform will require police and prosecutors to consider other measures for simple possession of drugs, such as diversion to addiction treatment programs. Ces réformes sont attendues depuis longtemps.
These reforms are long overdue. Indigenous people, Black Canadians, and members of marginalized communities, including those with mental health and addiction issues, are overrepresented at all stages of the criminal justice system, but especially in Canada's correctional facilities. This simply cannot continue. When we examine the factors that accentuate these issues of concern, it is undeniable that certain mandatory sentencing measures that reduce judicial discretion have had a disproportionate impact on members of these communities. These measures, intended to reduce crime by deterring offenders and isolating them from society, have proven to be ineffective, costly, and harmful.
Between 2007 and 2017, Indigenous and Black adults were more likely than other Canadians to be admitted to federal custody for an offence punishable by an MMP. Their admission to federal custody with an offence punishable by an MMP almost doubled during those years. For example, Black Canadians comprised 43% of individuals admitted for exporting or importing drugs in 2016-2017, and Indigenous people comprised 40% of adults admitted for a firearm-related offence that same year. Les réformes que nous proposons en matière.
Our proposed sentencing reforms align with recommendations made by social justice and criminal justice stakeholders over many years.
Reconciliation Commission noted the issue of overrepresentation of Indigenous people in correctional institutions and called for its elimination over the next decade. The National Inquiry for Missing and Murdered Indigenous Women and Girls also called for the government to evaluate the impact of MMPs on the over-incarceration of Indigenous women, girls, and 2S LGBTQIA people, and to take action to address the problem. The Parliamentary Black Caucus has also called for the elimination of MMPs. Le gouvernement est à l'écoute et prend des mesures appropriées.
The government is listening and is taking appropriate measures. We are repealing some, but not all. We are going to concentrate on the abrogation on those that have had the most impact on these communities, while guaranteeing that the courts will be able to impose penalties for violent and severe infractions. Allow me to be clear on this last point. These reforms will have no negative impact on public safety and do not indicate to the courts that these offenses are not serious. We are keeping MMPs for murder, sexual aggression, all sexual assault against children, and some involving firearms, or when there is a firearm and this is linked to organized crime. With respect to the second category of reforms, Bill C-5 increases the availability of conditional sentences of imprisonment, also known as CSOs.
Of incarceration of less than 2 years that is served in the community under strict conditions such as a curfew, house arrest, treatment, and/or restrictions on possessing, owning, or carrying a weapon. CSOs will increase access to alternatives to incarceration for low-risk offenders, while also furthering the sentencing goals of denunciation and deterrence. The evidence is clear. Allowing offenders who do not pose a risk to public safety to serve their sentences under strict conditions in their community can be more effective at reducing future criminality. Offenders can keep a job and maintain ties with their family and community. These measures bring back flexibility in sentencing by allowing judges to help people, not just jail them. For example, a judge can impose a CSO for an offender to serve their sentence at home while receiving appropriate mental health and rehabilitation supports. The measures allow communities to take on the responsibility for the rehabilitation of their members through a community justice program, which we are funding. Experts in the field and in the communities themselves tell us that this is the best way to move the community forward, to move society forward, and to help everybody, including victims, heal while maintaining public safety. That is what CSOs do. The reforms in C-5 will remove many limitations on CSO eligibility, but not all. CSOs will only be available for sentences under 2 years for offenders who do not pose a risk to public safety. I want to emphasize this part as I believe there is some misunderstanding that CSOs will become available for all offenders. But I repeat, they will only be available where public safety is not at risk. CSOs will also not be available for some offenses, including advocating genocide, torture, and attempted murder, as well as terrorism and criminal organization offenses when they are prosecuted by way of indictment, for which the maximum term of imprisonment is 10 years or more. Finally, while it is important to enact sentencing measures that aim to reduce recidivism and overrepresentation, it is equally essential to assure that there are adequate off-ramps at the earliest stages of the criminal justice process. This is especially true for conduct that could more appropriately be treated as a health concern. To this end, Bill C-5 will require police and prosecutors to consider alternatives to laying or proceeding with charges for the simple possession of drugs. Alternatives will range from taking no action at all to issuing a warning or, if the individual agrees, diversion to an addiction treatment program. These measures are in keeping with the government's public health-centered approach to address substance abuse and the opioid epidemic in Canada. The damage caused by failed criminal justice policy is not simply a Canadian problem. I was in Washington last month and met with a number of bipartisan groups and think tanks working on criminal law reform. The message from all of them was that incarceration has failed. Many states, both Democratic and Republican, have abandoned MMPs because they simply do not work. The reforms we are proposing are the reforms they are advocating: repealing MMPs, bringing greater flexibility to sentencing, and diverting offenders out of the criminal justice system in the first place. These are solutions that will address the problems we face. In addition to the reforms in Bill C-5, our government remains committed to work with our partners in the provinces and territories, as well as with Black, Indigenous, and marginalized community leadership, in order to eradicate the overrepresentation of these communities in the criminal justice system. Community safety is what we want. These reforms will help make that happen. I look forward to answering any questions that you have. Thank you. Merci.
Thank you, Mr. Lametti. Really appreciate your presence here today. And dear members, I've come up with a little, I'll use a green folder just to show when there's 30 seconds left, just so I don't interrupt your train of questioning. So I'll use that, and then I'll give you the grace of that 30 seconds to end your members' time. And the first round of questioning is to Mr. Moore for 6 minutes.
Okay, thank you, Mr. Chair, and thank you, Minister, for appearing. It's good to see you again virtually, and also to your officials that are appearing with you. Minister, I know you and I agree with each other from time to time. Bill C-5 is not going to be one of those times. I can tell you from the testimony that we've heard from our deep consultations with witnesses, with communities, both rural and urban, and including with various victims groups, this bill could not be more breathtakingly out of touch at the time we find ourselves in Canada. Removing mandatory minimum penalties for serious gun crime, house arrest for serious offenses against a person, Controlled Drugs and Substances Act, trafficking, production, and distribution minimums being eliminated for serious offenses that are plaguing our communities. This bill, quite frankly, is in the face of those who are calling for safer streets and communities, and is an affront to victims. I did hear in your opening remarks, it's quite heartening, and I'm sure Canadians will be relieved that you're maintaining the mandatory minimum penalty for murder. I guess that sets the bar fairly low, Minister. We're interested in making sure we have a justice system that's balanced and that protects the rights of victims and keeps communities safe. I want to jump right into questioning. According to Statistics Canada, women were violently victimized at a rate nearly double that of men in 2019. We know that part of this is due to the fact that according to Statistics Canada research, women were 5 times more likely than men to be a victim of sexual assault. And you, at your appearance at committee on March 10th, 2020, you stated that despite the robustness of our legal framework in this area, there are still extremely low rates of reports, charges, and convictions in sexual assault cases. Now, with your Bill C-5, Minister, sexual assault with a weapon, threats, or causing harm, as well as the offense of sexual assault under Section 271, both of those now have had mandatory jail time removed, and an offender can serve their sentence from the home community. Did you consult with victims of sexual assault before making the decision to allow their perpetrators to serve their sentence from home?
Thank the honourable member for his question. Thank you, Rob, if I may. Yes, we are going to disagree quite strongly on this. I think what is an affront is the continuation of a so-called tough-on-crime policy that has so clearly failed in Canada, so clearly failed in the United States, so clearly failed in other countries like Great Britain, and is being abandoned everywhere. And so it would be an affront to keep going with that without looking at the actual evidence and without actually assessing the actual impact that these minimum mandatory penalties of the lack of conditional sentence orders are having in the system. And that's what we're trying to do here.
Thanks, Minister. I don't have a
Rob,
ton of time, so right to my question.
Yeah, the CAO, I don't know where you're getting
victims of sexual assault.
I'm not sure where you're getting the information that we've removed CSOs for sexual assault. That is, we've removed minimum mandatory penalties for sexual assault. That's just simply wrong. And let me point out two things. First of all, conditional sentence orders, as I have said, will only be available to a judge where the sentence would have been less than 2 years. So obviously not in a case where there's a minimum mandatory penalty that's higher than that. And in no case will they be allowed where there's a threat to public safety. That's the sine qua non of what we're doing here. So the kinds of situations that you're referring to simply don't exist. Serious offenses will always be punished seriously. Sentencing judges will always take the context and circumstances into account, and they will go towards the other end of the sentencing spectrum where it is merited. What we're doing here is giving the flexibility back where there's some other contextual reason that means that the best place for the victim, the best place for the person, the best place for the community is not to incarcerate the person.
Sorry, yes, thanks, Minister. I mean, where I'm getting the information.
Merci, Monsieur le Ministre. Alors, là où je trouve l'information sur les...
I'm sorry, Mr. Chair. I'm getting the French translation into my headset, but okay, I'll continue on.
I think it's been corrected, Chair. Mr. Moore. I believe I got the same.
Thank you, Mr. Chair. I mean, where I'm getting the information, Minister, is directly from Bill C5. Offenses where a conditional sentence would be available include sexual assault with a weapon, threats or causing harm, trafficking or exporting, fraud over $5,000, robbery, breaking and entering and robbing to steal a firearm. These are offenses that are taking place in all of our communities. And under your bill, now the perpetrators will be able to receive conditional sentence, otherwise known as house arrest, rather than jail time. And Minister, I'd like an acknowledgement on the source of many of these mandatory minimums that you say are for not serious offenses. Do you know the origins, for example, of the mandatory minimum of using a firearm in the commission of an offense and weapons trafficking in the criminal code, where those mandatory minimums, do you know when they were introduced?
Very briefly, Minister.
Thank you. I believe those were introduced under a Liberal government. Correct me if it's under Prime Minister Martin or under Prime Minister Chrétien. But the
one
fact
of them was introduced under Prime Minister Pierre Elliott Trudeau in 1976. The other under Jean Chrétien in 1995. The point
Thank
being,
you, Mr.
Minister,
Moore.
these
I'm
are
going to have
serious
to get
offenses.
you to. Thank you.
Point, Mr. Moore.
Go to the next panel.
The point, Mr. Moore, is that there was a rapid increase.
Minister, I'm going to have to ask you to perhaps answer that in the next question, or hopefully the next member will allow you some time to answer that. Madame Briard, for 6 minutes.
Merci, Monsieur le Président. Alors, Monsieur le...
Thank you. Mr. Minister, I'll give you the opportunity to continue your answer that you were providing. Thank you. Thank you. So, the movement, even if there were some MMPs under Trudeau, Chrétien, and Martin, most of them were implemented by the Harper government, as well as removing the option of having CSOs. And so there was a movement towards overrepresentation and over-incarceration in Canadian prisons. This is clear. And this being said, we need to repeal these. They don't work. And we've chosen about 20 where public safety is not at risk. When we're talking about some offenses, Mr. Moore makes of the fact that in offenses that he named, there are some MMPs that will remain. For example, anything with prohibited firearms or restricted firearms, if these types of firearms are used, and in the case of organized crime. So what we're seeking here is to deal with offenses with a firearm and there's an overrepresentation, especially of Indigenous peoples. There's a huge overrepresentation. So we are trying to correct this. Thank you. In your statement, you spoke to your visit to Washington. Many organizations in the U.S. are working to try to change decades of failed policies. Could you speak to your visit in Washington and what you learned from these organizations? Thank you. I met with experts from the Center for Justice and the Council on Criminal Justice, and these are bipartisan organizations, and they're experts in the field, and they saw the overrepresentation figures in the U.S. and also the efficacy of incarceration in the U.S. And they are recommending the same things as we are here today, to reduce or eliminate mandatory minimum sentencing, to have increased flexibility in the determination of the sentence, for example, for CSOs, and diversion. We're trying to deal with these cases where there's no health, public safety issue. We had a document on Bill C-5, and this indicates that repealing MMPs is in the framework of measures seeking to promote discretionary power of justices in the matter of sentencing. The bill will not repeal all MMPs. So if the judge's discretion is important for some offenses, does it mean that it is not in the case of other offenses? Of course, we are targeting a very specific issue here. That is to say, overrepresentation of Indigenous peoples and Black people, people of color in the legal system. And we looked at offenses where we could clearly demonstrate that there was this overrepresentation. That's not to say that there are not other measures that could be assessed. At this point, we would like to go forward carefully in order to target a very specific issue, and that is why we chose these particular offenses. Thank you. Earlier, we talked about overrepresentation. So Bill C-5 also brings an important discretionary power to police officers and prosecutors. How will these changes impact overrepresentation of these groups in the carceral settings? Answer. When we're talking about addictions issues, for example, it would be preferable to deal with the addictions issue as being a health issue. So to put someone before a judge during a trial and to incarcerate them is not the most efficient way of improving not only their situation, but the community, their family, etc. Here, we can find other solutions. First of all, we can reduce the number of people in the correctional system, and we can redirect them towards health services required. With a CSO, we could also elaborate or set out a sentence where the person would be able to keep their job, stay with their family, find the necessary support in order to improve their situation, in order to have reconciliation with the victims.
Thank you, Minister. I'll next go over to Monsieur Fortin for 6 minutes.
Merci, Monsieur.
Thank you. Hello, Mr. Minister. I'm very pleased to have you with us today. And I would like to begin with the same caution of Mr. Moore. I'm not sure that we're going to agree on this issue, Mr. Minister, even if the Bloc Québécois has always, historically speaking, been in disagreement with MMPs. We believe that it would be preferable to allow judges to determine the sentencing in most cases, but not all. And on this issue of decriminalization, if we're talking about the use of small quantities of drugs, oftentimes these are healthcare issues rather than legal issues. So we might agree on that. But as for C5, as it is laid out, Mr. Minister, we do have some problems. First of all, you said that this bill had been proposed to fight against systemic racism. Well, I would tell you that really you're grasping at straws, because the issue of systemic racism is a huge issue, and we'd have to deal with this, but we would have to determine what it is. Actually, I'm not sure that systemic racism, in the sense that the government understands it, really exists, but that is another issue that won't be dealt with today. But I think that reducing sentences for some crimes in order to avoid that racialized people are sent to jail is a strange way of dealing with systemic racism. I'm going to ask more specific questions. I only have 6 minutes, and now just 5. And as you can imagine, we won't be able to deal with the entire issue, but I know that you're saying that for MMPs for very serious offenses will remain. But in your opinion, Mr. Minister, is firearm trafficking something that is serious or not? It is serious, and that is why the large majority of offenses. Yes, that was my question. Sorry, but no, I'm trying to answer your question. I only have 5 minutes. Well, allow me to answer. So it's a serious offense. I've understood. So it's not included in the bill. Mr. Chair, I want to have my time. Mr. Minister, is firing a weapon with intent, is that a serious crime? If, given the circumstances, it is serious, there will be a sentence that will be a long sentence. Yes, but firing a weapon with intent, that's not really serious? Answer. In some cases, we've even seen some legal cases where it wasn't necessarily the case.
Le témoin, il a le temps de répondre, Monsieur le Président, mes questions.
My questions are simple, and he has answered, so I only have 5 minutes. It's not up to you to determine what the answer is going to be.
Pas beaucoup de temps. Alors, Monsieur le Ministre, faire un vote.
Mr. Minister, armed robbery, is that serious? Mr. Fortin, we have mandatory. We're targeting mandatory minimum sentences in cases. The interpreter's sorry, but there's 2 people speaking at once.
Pas dire que quand les circonstances
Point of order.
Yes, point of order for Mr. Brock.
The last 3 or 4 minutes have been very, very difficult to understand. The interpreters are speaking over each other, and I, quite frankly, could not follow the line of questioning nor the responses.
Mr. Fortin, I would ask if you, once you ask a question, you allow the witness to respond and then let them know you're asking the next question. When we do crosstalk, it's very difficult for translation services as well, and the echoing also overlaps in that.
Point of order, Mr. Chair, point of order.
Yes, Mr. Morrison.
Yeah, I think, though, Mr. Fortin, he asked a question, got a response, and was good with that, and the minister kept talking. I think if we are limited to 5 minutes and we want we get one answer and that we want to carry on with another question. Otherwise, the minister could continue likely to talk for the entire 5 minutes, and I don't think that's correct either.
So, point of order here as well.
This
is ridiculous.
Yes, I'll take it from, I believe, Ms. Diab spoke, and then Mr. Anand Sangari.
I'm just, a point of order here. We need some respect in the line of questioning. I don't believe, I think, Monsieur Fortin, vous avez pris tout le temps.
I think you took all the time to ask the question, and that's why there's not enough time for the minister to answer. If you really want an answer, it's necessary for you to give the minister a few seconds to answer at least. We have to have some respect within the committee here. Please. Mr. Chair.
To Mr. Anand Sangari, and then I'll return to you.
Okay. Thank you, Mr. Chair. I think there's a general convention in Parliament where the response time equates very closely to the time for the question. So in the sense here, when Mr. Fortin does ask a question, he needs to give adequate time for a response. He cannot cut off the minister and go to the next one. I think we all recognize time limitations, but I think we've all generally been, very much in adherence to these conventions, and I hope that we can continue the meeting where there's adequate time given for a response without interruption, and so that we can actually hear both the question and the answer and understand, especially with translation, it is a bit more difficult, and especially for our interpreters who have been working around the clock.
Monsieur le Président, votre micro.
Mr. Chair, you're on mute.
Mr. Fortin, over to you, and then I'll...
Monsieur le Président.
Mr. Chair, thank you. I'm trying to mention that I agree with what my colleagues have said. More specifically, what Mrs. Diab said. I respect Mr. Minister Lametti. He is very respectable, but he's a specialist in the matters of justice. He's a very erudite gentleman, and I could speak with him all day. But I only have 5 minutes to ask my questions. I'm already losing time because of interpretation. We've talked about this a lot, and I've proposed a lot of time to have extra time if the answers are being asked in a different language. So I am dealing with this issue, and I do agree with Mrs. Diab. This is why I'm asking specific questions to the minister. The questions that can be answered by yes or no. I'm asking if, in his opinion, if arms trafficking is a serious crime, if armed robbery is a serious crime, if it's a serious crime to discharge a firearm with intent. And so this can be answered with yes or no. If there's a 4 or 5 minute answer, I won't be able to ask more than 1 or 2 questions, and I'll be losing my time. And so I think that we have the right to have clear answers. The minister wanted to introduce and say he could have made his statement, but now we have the opportunity to ask questions, and it's important for the minister and for citizens. And I think that we can expect short answers if the question is a short one. Thank you.
Order, Mr. Speaker. Mr. Fortin, I'm just going to ask that I'll go to Mr. Naqvi next as well, but. Just to respect the amount of question, the time that you ask the question, to give at least the same amount of time to answer the question. I know you're expecting perhaps a yes or no, but if you have a 10-second or 15-second question, at least give the witness 15 to 20 seconds. Just because of interpretation too, it takes a few seconds longer, and it goes both ways, the interpretation, and we all want to listen to your questions and have it on the record. So Mr. Naqvi, and then I'll try to resume after this.
I just want to make one point, and this has been in my mind for some time. We're dealing with some complex criminal justice and legal issues here. There is no such thing, and Mr. Fortin knows, as a yes or no answer. These are nuanced issues that requires thoughtful, nuanced answers, and I think there should be time given to all our witnesses, not just to a minister, to all our witnesses, to be able to articulate their thoughts properly. Thank you.
Thank you, Mr. Naqvi. I will.
Order.
Yes, Mr. Moore.
Sorry, Mr. Chair, with all this discussion about how we ask questions, how we answer questions, it's taking up a lot of actual question time. We only get the minister here so often. So to you, Mr. Chair, I'm hopeful that the minister can stay maybe an extra 15 minutes to make up for some of the delays we're experiencing debating how questions are answered and asked.
Thank you, Mr. Moore. I can't control the minister's schedule or his itinerary. My office, we are here as members and we're here, but I'll leave that to him. But hopefully we'll be able to get a round of questions for everyone. And I'm just going to ask, this committee's actually done a very good job in the past, even though this is the first time the minister's coming here. And I know we're all excited, but just stick to quorum, and I think we should be okay. Mr. Fortin.
Point of order, Mr. Chair.
Yes, Mr. Brock.
In furtherance to my colleague, Mr. Moore's commentary, and in reflection of my colleague, Mr. Yakvi's commentary about these are nuanced questions and more importantly, nuanced responses, perhaps the committee can consider inviting the minister back for a further hour at a future date, because obviously there is a lot of questions that all members from all parties wish to ask the minister. And he's got lengthy responses, so perhaps a further 1 hour might be warranted in the circumstances.
Thank you, Mr. Brock. I think we'll look at that afterwards. We still have an hour of department officials who have a high level of expertise in this, and we should listen to them. But I'm going to resume to Mr. Fortin to continue his questioning, and I've added some time for you, Mr. Fortin, for the disruption. You have about 2 minutes, 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Minister, thank you for your previous answers. And once again, I reiterate that I respect you very much. We're limited in time. And I do accept the decision made by Mr. Chair, who suggests that you have the same amount of time to answer as the question. So here was my next question. Armed robbery. Do you consider this as being a serious crime? Mr. Fortin, it's determined in the circumstances by the justice. It can be or not, depends. Extortion with a firearm. Is this serious or not serious in your opinion? The severity of the crime is always determined, Mr. Fortin, by the judge, by the trial judge. It can be serious or less serious, depends on the circumstances. To commit trafficking, discharging a firearm with intent, armed robbery, extortion with a weapon. All of this is not necessarily a serious crime, according to you, and it all depends. It all depends on the facts and the circumstances. Excuse me. This is why there is discretionary power granted to the judges, the trial judges, so they can determine, given the circumstances, the level of severity of the crime and what will be the sentence. Mr. Minister, you're aware that there's an increase in armed violence, especially in Montreal, but throughout Canada over the past few years. Do you think that this is the right message to send out to the population, that to repeal mandatory minimum sentences is a correct message? We're aiming at another issue. So I was very pleased during the first tabling of the bill that you supported publicly in the House of Commons, the same bill. But what we're doing right now here, and my colleague, Minister Mendocino, is, as we said during the election campaign, he's dealing with firearms and trafficking in Quebec.
C'est presque inutile ces rounds de questions-là quand on est limité. En tout cas.
This is almost useless with this time limit.
Round to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I thank the Minister for being here today. I know that one of the motivations behind C5 is to address systemic racism in the justice system, but I want to ask about what I think is very closely related, and that's the overdose crisis in Canada. In British Columbia, in 2021, 2,224 people died from an overdose and a poison drug supply. And that's at least 2,224 families who lost fathers, mothers, sisters, brothers, kids, cousins, neighbors. And so this is a rapidly increasing problem. And so I know that one of the ways you've talked about in this bill is diversion and reducing mandatory minimums. But the First Nations Health Authority in British Columbia reported that Indigenous British Columbians are 5 times more likely to experience overdose crisis and 3 times more likely to die from that overdose crisis. So I guess my question to you, Mr. Minister, wouldn't it be better simply to eliminate the possession, the criminal offense of possession of small amounts of drugs for personal use?
Thank you, Randall, for that question. Look, I share the concern. I certainly share the concern that there's an opioid crisis, not only in Vancouver and British Columbia, but across Canada, and it is one that is serious. What I'm trying to do is attack a specific problem with sentencing reform. I would be open to other ways of attacking that problem, particularly working with experts on the ground, with governments of British Columbia and Vancouver, with my colleagues, the Minister of Health and now the Minister of Mental Health. And I don't think we should close off any possibility to solving those problems. I would also be open to other criminal law reform. I certainly am investing in community justice centres in British Columbia, particularly in the Indigenous community that are Indigenous-led, that actually work with Indigenous offenders, many of whom will have problematic addictions and opioid challenges, and that's another way that I can do it, but I'm willing to work with other colleagues across the board, and I'm open to ideas.
So, Mr. Minister, my colleague from Comox Alberni, Gord Johns, has a private member's bill, C-216, that would do exactly that, would decriminalize personal possession and make a lot of other changes around the possession offenses that would get people into treatment rather than the justice system. So are you saying today that your government's prepared to consider that private member's bill?
That would be, look, I'm not going to preempt a decision that might be made down the road, but certainly I would certainly consider it with Mr. Johns as well as with my ministerial colleagues and others who are interested.
Thank you very much, Mr. Minister. One of the other criticisms of this bill that I have and many others have is that it only picks out some mandatory minimums. And while I do agree with you that I do support maintaining for some of the most serious violent crimes, there's a lot of other mandatory minimums that could be removed. And there has been a bill in the Senate several times, it's now S-213, that aim to restore discretion for judges, even where there's a mandatory minimum in place, so that if a judge found there were extenuating circumstances, they could ignore those mandatory minimums. I wonder what your opinion is on that approach as well.
Look, it is an approach that I evaluated in the conception of this particular bill. And certainly, you know that I'm always open to working in good faith with colleagues around this table and in the House of Commons across the aisle to make any bill that I'm proposing better. So I'm always open to that. I didn't go with that approach for a variety of different reasons. I thought the bill that I have tabled is attainable. I think it's feasible. And I think it will be effective in targeting systemic overrepresentation.
Thank you very much, Mr. Minister. Yes, of course, we've had a good relationship and good dialogue and all these things. So I'm going to ask you about something we have talked about privately so you can say it publicly. And that's the question of expungement. So those who get involved with the justice system for personal possession end up with criminal records that often make employment and housing difficult to find. And this bill doesn't actually deal with expungement for previous convictions. And I wonder what your answer is, even though I know it.
We have it falls under the domain of my colleague, Minister Mendicino, the Minister of Public Safety. We did have expungement for the LGBTQ crimes. I'll put them in air quotes for members of the public service when we made that apology. We expunged those crimes because we wanted those crimes to be treated never as having been a crime. We introduced pardon reform after cannabis, using the word pardon and creating an expedited pardon process because those were illegal activities before we legalized we legalized cannabis. So that was the distinction. it's for my colleague to look at pardon reform. I know that he is thinking about it. I know that his predecessor, Minister Blair, thought about it as well. And I understand the impact that pardons have. It's also something that I heard in Washington from reformers, bipartisan reformers in the United States.
We in the Democrats often talk about automatic expungement because one of the things we've seen in the previous attempts for expunging records or having expedited pardons is that an expensive or convoluted process is one that the very people we're trying to help here have the most difficulty accessing. So they don't have resources to hire a lawyer, they don't have resources to pay fees, they don't have access to the internet on a regular basis. So I guess I would urge you in any discussions with your colleague to remember the people we're trying to help here have a very tough time accessing those kinds of proceeds.
Thank you, Mr. Garrison. And next for a 5-minute round to Mr. Brock, please, for 5 minutes. Mr. Brock, you're still on mute.
My apologies. Thank you, Mr. Chair, and thank you to the Minister and department officials. Thank you for your attendance. My first opportunity of talking directly to you, Minister. So hopefully I'll get a number of questions in. The first one I want to bring to your attention is I just wonder about the timing of your introduction to this particular bill. I remember that day very clearly because less than 24 hours removed from you presenting Bill C-5 in the House, we stood in solidarity as members of Parliament in the entire House to commemorate the École Polytechnique massacre from several years ago. And we stood for the message that the government would stand strong against all forms of gun violence, and to inform Canadians in very clear terms that we would take immediate steps to curb the ever-increasing tide of that criminal behavior. And I think you'd agree with me, Minister, that the number one responsibility of a federal government is to keep its citizens safe. Do you agree with that?
Look, I'm a Montrealer. I know Polytechnique. I've been in the building. I've been in the room. I knew graduates. I know graduates of that program. And I remember the devastating impact. I remember where I was when I got the news. And so I remember that very well. And we take gun violence very seriously. We as a government have reinstituted investing against gun violence across Canada. We have banned assault weapons, the kinds that were used to perpetrate these kinds of crimes. That the kinds of weapons that only have a place on the battlefield.
Thank you, Minister.
We've also
Minister,
fought gun. We've also fighting trafficking. We've invested historic sums and reversed the lack of spending that the previous Harper government failed to do.
Mr. Chair.
Thank you. Continue, Mr. Brock.
Thank you. Same day that you introduced Bill C-5, you're quoted as saying, "This was not aimed at hardened criminals, but first-time low-risk offenders." Specifically, you said, think about your own kids. Perhaps they got into trouble at some point with the law. I bet you would want to give them the benefit of the doubt or a second chance if they messed up. Well, it is a lot harder to get a second chance the way things are now. With all due respect to you, Minister, that tone-deaf response is not what Canadians wanted to hear 1 day removed from the commemoration. 1 day removed from us standing in solidarity against gun crime. You know gun crime is on the rise across all of Canada, and particularly in my riding of Brantford-Brant. You then, this week, April the 6th, did not respond directly to a question posed by a Conservative member from Kamloops, Thompson, Caribou. He brought to your attention the situation of a drive-by shooting which this legislation encaptures. He asked you specifically, Minister, how is that not a threat to public safety? The government could put into place a constitutional safety valve and have mandatory minimum penalties with exceptions to address the problems of over-incarceration, that this would provide a perfect middle ground. Why wouldn't the minister, why wouldn't the government consider that? Your response, sir, was as follows. The fallacy of the member's argument is clear. We are eliminating MMPs to eliminate the bottom range for all offenses. And then you drew another example. What we are talking about here is where a person has a few too many on a Saturday night and puts a couple of bullets into the side of an empty barn. So my question to you, Minister, is the discharge of a firearm with intent or recklessly deserves jail time. Would you agree with that or not?
The seriousness of the offense under all of these criminal code offenses, and you know this as a former Crown, depends on the circumstance. And we're talking about sentencing here. It's up to the judge to determine, according to all the facts in front of the sentencing judge, to determine the seriousness of the offense in question. It's still the same offense in terms of, actus reus mens rea, but there are different degrees of seriousness. And serious offenses will always be punished seriously. A drive-by shooting is going to be punished seriously. There's going to be serious criminal time, jail time associated with that. It is an affront to Canadian people to try to mislead them otherwise. What we're talking about are offenses, and I base that example on a real case. That person who did that one night, he had a job, he had a girlfriend, he was going to school. He had a few drinks too many that evening. He put a few bullets into the side with his shotgun into the side of an empty barn. There was nobody around, but a neighbor heard it and called the police. He got charged with a minimum mandatory penalty. He got 4 years. He lost the job. He lost the girlfriend. He lost the education. And when he left prison, he ended up moving into the same house with the people he'd served time with. So that's the education that he got. And that's what we're doing here. That wasn't a serious set of circumstances that deserved jail time, whereas a drive-by shooting certainly would.
Minister. Thank you, Minister. In the interest of time, I have to move on. Minister, next we have Member of Parliament Naqvi for 5 minutes.
Thank you very much, Mr. Chair and Ministers. It's good to see you here today. I'm interested in learning more about conditional sentencing orders. That is also part of Bill C-5. At a time when I had the honor of serving as the Attorney General of the Province of Ontario, we introduced a similar notion dealing with bails, introducing bail beds in the province. In fact, I recall making a certain announcement with Mr. Brock when he was a Crown prosecutor, and he was quite supportive of that initiative. But it was an opportunity to allow people, again, who have some serious mental health or addiction challenges, instead for being remanded and incarcerated while they're waiting for their trial, to have them in a community setting under strict conditions where they can get support services. And there was ample evidence that demonstrated that would be far more beneficial to them, to the society in general. What kind of evidence and benefits have you seen in terms of use of conditional sentencing orders that has compelled you to reintroduce them through Bill C-5?
Thank you for the question. It's wonderful to have two former attorneys general around the table with me here this afternoon. There is a mountain of evidence on conditional sentence orders and how flexibility, this kind of flexibility in sentencing, that shows positive impact, not just for the rehabilitation and the reintegration of the offender, but for victims and for communities. Having conditional sentence orders allows us to attack the real problem, be it problematic addiction, be it intergenerational trauma, in the case of racialized communities, be it poverty or be it lack of housing. Those are the problems we need to attack. What a conditional sentence order allows us to do, instead of sending a person to jail, and oftentimes in the case of a woman then having to take her kids into custody, it allows us to keep that person at home, getting the treatments that they need, perhaps keeping the job, staying around the community supports that they have. I would also add that it allows us to realize the potential of investments that we are making for Indigenous peoples with GLADU reports, which allows a sentencing judge to craft a sentence based on what is in that GLADU report. Or we've now started a pilot project on IRCA's impact of race and cultural assessments in Nova Scotia, in Montreal, in Toronto, which allows the sentencing of black offenders a similar kind of sentencing report to a Gladue report. And again, a conditional sentence order allows for the potential there. Without a minimum mandatory penalty, no harm to no public safety threat to the community. It allows the judge to actually craft a sentence that will be beneficial to everybody in the community, the victim, the offender, and everyone around. It allows communities also to take charge of sentencing and rehabilitation in a very positive and proactive way. This is something that expert groups, particularly across North America, are recommending.
Thank you. And I thought it was quite harmful or devastating when they were taken out of the criminal code. And I think this opportunity of giving a judge to look at overall circumstances, especially as it relates to Indigenous peoples, Black people, and racialized people, is extremely important. I know you alluded to when you were talking about MMPs and having its sort of broader impact on Indigenous, racialized, and Black peoples. Can you talk about some of the data that you have seen that demonstrates how MMPs have been overly utilized when it relates to Indigenous peoples of Canada, Black folks, and racialized people?
Again, thank you for the question. There are certainly a number of studies and statistics with respect to overrepresentation and with respect to MMPs in particular. So, you know, the statistics, they're Black, Indigenous peoples represent a tiny percentage of our population, but 30% and higher of people in federal incarceration. The number is even higher for Indigenous women. Black population of approximately 3% of the population, I believe, is, again, close to 9% of all offenders. With respect to MMPs themselves, of all admissions to federal custody between 2010 and 2020, 53% of Black offenders and 36% of all Indigenous offenders were admitted for an offense punishable by an MMP. Those are shocking statistics. It is simply inexplicable for any other reason other than systemic racism that those numbers are that high. And therefore, we need to attack the problem at all levels.
You.
Sentencing is one of them, but there are other places, too, where we need to attack this.
Thank you, Mr. Naqvi. And next, for a 2.5-minute round, to Monsieur Fortin.
Merci, Monsieur.
Thank you, Mr. Chair. Mr. Minister, I have to say that I agree with you and what you were saying earlier on the fact that there be or no MMP in the case of serious crime. Oftentimes the judge will impose a sentence of imprisonment, and that goes without saying. And I agree with you. And I agree with you when you gave this example of someone that fired into an empty barn. Probably not necessary to send this person to jail for 4 years, but it might have been good to say that discharging an firearm with intent on an anonymous object is one thing, but on a person, well, that requires a mandatory minimum sentence. Maybe that's what we will suggest as an amendment in the committee report. We'll see. This being said, Mr. Minister, do you agree with me to say, well, first of all, laws evolve with time. The current criminal code is not the same as the criminal code we had 10, 20, 50, or 100 years ago. And the reason why laws evolve is that legislators have to legislate according to the concerns of the population at the time. And so if you agree with this, Mr. Minister, why today are you legislating to withdraw, to repeal mandatory minimum sentences in case of using a firearm in the commission of a crime when we see an increase of violence related to firearms? And this concerns people. We see mayors saying that they hesitate, mothers saying that they hesitate to send their children to school because there are firearms in the schools. So, Mr. Minister, the timing is bad.
Les armes à feu qu'on vise.
The firearms that we're targeting here with repealing MMPs is not firearms used by street gangs in Montreal or elsewhere, or and it's not assault weapons. And as a government, we are fighting against weapons trafficking and gangs, and we're doing that in a historic fashion. So we hear the concerns of the population, and we are acting with measures with provinces, with Quebec, and with municipalities. But what we're doing here is that we're targeting another issue, and that's overrepresentation in the legal system of Black and Indigenous peoples. And this is a real issue, and we are dealing with this real issue. So, Vice
Minister there. I'll next go to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I know Bill C-5 is targeting systemic racism, but there's another impact of mandatory minimums that has been a concern for me since everyone's citing their past as a criminal justice instructor for 20 years. And that is the situation of women who are in abusive relationships or coercive and controlling relationships, and often end up in the justice system as a result of activities of their partners, and in particular around drugs, quite often being forced to deliver or hold drugs on behalf of a coercive partner, and therefore end up under mandatory minimums. So I wonder if the Minister has any comments on how the bill will impact women who come into conflict. And again, a lot of those women are Black women and Indigenous women because of systemic racism.
Thank you for the question. There's absolutely no question that that's one of the situations that we're attacking here. Women who, for no fault of their own, are drawn into a relationship or controlled in a relationship or have a problematic addiction within the context of a relationship, that seeks them to seek out, that forces them to seek out a relationship in order to maintain that dependence, and then end up becoming a mule or being charged with possession or other things. We're trying to keep those women out of the criminal justice system. We're trying to keep those women. We're trying to give those women a sentence that fits the crime, that allows them to seek the help that they need, get the help that they need, while remaining safe. All of that is I think, part of this package, and we think it will have a great deal of success, particularly the interaction of the minimum mandatory penalty and the conditional sentencing order working together.
One of the things I've often heard from both defense attorneys and prosecutors locally is that mandatory minimums actually contribute to court delays by making a lot of cases go to court which might not otherwise if they were able to reach a deal that in the absence of those mandatory minimum penalties being on the table. I just wonder whether the department has looked at that problem.
Very much so. They cost us a massive amount of money. The minimum mandatory penalties reduce the amount of plea bargaining in the system, so more cases go to trial. They increase the number of charter challenges. Over a third, and possibly even higher of all the charter challenges in the system are on minimum mandatory penalties, and many of them, about half of them, actually succeed. These clog up the system, and they cost us money. And so when other people walk free on serious crimes because of a Jordan ruling, it's in large part caused by the massive logjam that is being caused by minimum mandatory penalties. And if you look at the introduction of MMPs under the Harper Conservatives and the taking away of CSOs, the numbers of court cases just go up and the delays go up. So we're attacking that too.
I want to thank the minister for his time and staying over. I think we're about 3 minutes into the intervention, but I've used my liberty to go over 7 minutes. So I want to thank you, Minister Lametti, for coming and appearing before our committee. You're always most welcome to come back. I'll now suspend for a few seconds just while you can leave, and then we'll resume with your officials who will remain for the remaining hour and for the next round of questions.
Merci, Monsieur le Président. Merci à vous tous.
Oh, thank you, Mr. Chair. I'm just wondering, I have a question. I don't know who any one of the panel can certainly answer this, but do you believe that there is an overrepresentation of Indigenous, Black, other marginalized communities who are victims?
In fact, what the available data shows is that Indigenous persons, Black Canadians, and members of marginalized communities are sometimes both overrepresented as victims and as offenders in the criminal justice system.
Okay, great, thanks. I'm wondering if, you know, when we talk about long-term solutions, and we're talking, I think this is short-sighted in my opinion. But for long-term solutions, we look at crime prevention. So we look at how do we tackle the fact that we have, for example, let's go to the opioid crisis, which is part of this bill. How do we actually resolve the issue of the opioid crisis in a crime prevention manner versus crime reduction, which of course is putting people in jail? And I am way soft on that. I do believe we need to have a crime prevention program. I'm wondering if you or anyone in your area has discussed how we can have a long-term solution here.
What I can say about Bill C-5 is that it's just one of the mechanisms that the government has put in place to reduce criminality, but also to impose fairer sentences that will serve the communities themselves. Some of the measures in Bill C-5, like with respect to mandatory minimum penalties, restore judicial discretion, and the same thing with conditional sentences of imprisonment. They allow judges to impose sentences with a community-based sanction when appropriate. And with respect to the Controlled Drugs and Substances Act, again, there are mechanisms there that allow the criminal justice system to keep individuals outside of the criminal justice system and to get the help that they need.
Okay. Do you support and have you budgeted for the increase in policing, for example, that will be required, especially under the CSOs, that they're not doing today? Is there a plan, or have you? I didn't see that in the budget yesterday. Is that there? Are you anticipating supporting law enforcement agencies that will need that support under the CSO program?
It's reasonable to expect that the reforms to CSOs will have a greater demand on treatment programs at the outset. However, what we see is that mandatory minimum penalties are extremely costly in the criminal justice system. They increase charter challenges. So what ends up happening is if we implement the reforms in Bill C-5, we expect that over time, while there will be an initial increase in those requests for treatment and programs, we'll see long-term reductions in recidivism, and we can expect that there'll be better, more efficient ways of dealing with crime.
I wonder if you can talk about to come up with this plan that you have and picking these particular sections for reducing mandatory minimums, the research you did, and when you brought victims who were associated with these offenses, how the victims responded to your plans to remove penalties. For example, I want to think about an abduction of a person, like say my daughter who's 14 years old and assaulted and held against her will. How happy would I be that that individual would actually qualify for a CSO and come right back to that community?
Thank you for that question. The Department of Justice did conduct public opinion research, and it initially shows that Canadians are supportive of MMPs at the outset, but once they're informed about the negative impacts on the criminal justice system, they overwhelmingly support an approach that's more nuanced and that's currently permitted under the law. I don't want to purport to speak on behalf of all victims because they're not an homogenous group. However, as part of the, as part of the 2017 National Justice Survey conducted by the Department of Justice, most Canadians responded to a survey that they were not supportive of MMPs, 91% indicating that Canada should give judges flexibility and impose sentences that are less than the MMP.
Yeah, and we're going to certainly, that's part of our committee's job, is we'll be bringing in witnesses who have been victims, and we'll hear firsthand exactly how they feel about removing some of these mandatory minimums. I was so happy about one thing that the minister said, and that was organized crime. Organized crime, gang activity is not in this this particular reduction of sentencing. Did I hear that correctly?
You are indeed correct. Many of the mandatory minimum penalties that will remain after C5 is adopted are 5 and 7 year mandatory minimum penalties where a restricted or prohibited firearm is used, where it's where the offense is in connection with organized crime. The mandatory minimum penalties that are targeted, let's say, for firearm offenses in this bill are the ones in any other case category, which particularly relate to the use of firearms like long guns.
Okay,
thank you, Mr. Morrison. Your time is up. Next, I would go to Madam Diab for 6 minutes.
Thank you very much, Mr. Chair, and thank you very much for the witnesses for being here this afternoon. Very important research or meeting that we're doing here, and I look forward to all the presenters that will come forth. So, in my time in Nova Scotia, when I was involved in the justice portfolio, in Nova Scotia, we have ridiculously high number of overrepresentation in our correctional facilities of Black Nova Scotian and Indigenous, and I would say overwhelmingly the research shows that and the evidence is clear from many people that had spoken on it since those years and now, that there's clearly a problem in our system. And can you speak to me in relation to that, and what consultations informed the development of C5, specifically with groups representing racialized groups and Indigenous people, or provinces like Nova Scotia? What have you heard, and can you sort of tell me the impact of the MMPs would have on that overrepresentation? And I will to whoever is able to answer that. I'm not sure who the.
So I can start by saying that there hasn't been specific consultations on Bill C5, but there was consultations done, the Criminal Justice System Roundtables in 2016, and the mandatory minimum penalties that are being targeted in this bill are the ones that are particularly associated with negative disproportionate impacts on Indigenous people, Black Canadians, and members of marginalized communities. As the minister noted earlier, Indigenous persons are overrepresented with respect to certain firearm-related offenses, and the same goes for Black Canadians, who are overrepresented with respect to import-export offenses. I can also say that there's 1 in 5 Indigenous women that are serving a sentence for a serious drug offense or conspiracy to commit a serious drug offense, and that by repealing the mandatory minimum penalties in those cases, the government is restoring judicial discretion to impose fit sentences in all cases.
Let me ask a question in relation to I think part of the bill gives, and I'm not sure exactly where it is, but I read a part of the bill would give more discretion to prosecutors and to police. Is that correct? And I guess I would, do you see that as a concern from those marginalized communities being, in the system with that. Can you comment on that for me?
I can say that the reforms to the Controlled Drugs and Substances Act enact a declaration of principles for the first time in that federal legislation. And that would principles that are based on former bill, Private Members Bill C-236, which treat drug-related offenses or the use of drugs or simple possession of drugs as a health and a social problem rather than a criminal one. And where the police officer fails to exercise their discretion to divert at the first point of contact, Crown prosecutors have to apply the exact same principles, and those principles are informed also by August 2020 guidelines of the Director of Public Prosecution, which tells us to focus on the more serious offenses, drug-related offenses, the ones that endanger public safety, and to redirect those cases that are less serious out of the criminal justice system at the first point of contact.
Here we go. Thank you for that. Conditional sentence orders. We've heard, and my experience tells me that they allow offenders to remain embedded in their communities while serving their sentences, obviously, and of course, when the offense and the crime, it's appropriate for them to do that. We know that community support is vital to the process of managing mental health and addiction challenges, which is extremely difficult to treat when people are incarcerated. Can you elaborate on, and I know the minister talked about this, but I would like to have some more on that, what the data shows on the difference in the outcomes here for offenders and community? Like that, to be frank with you, when I was as Justice Minister and Attorney General in Nova Scotia, we started the mental health court system. And, not unlike that takes the individual and gives them all the wraparound service. And, in my time, we had a 5-year anniversary. And the results that came out of that were, unbelievably helpful and to the individual, but also to the community and to everyone involved. So I'm going to give you the time, whatever I have remaining, to sort of elaborate a little bit more on that, if I.
Unfortunately, Ms. Diab, you don't have time. You're a few seconds over. Hopefully, the witness will be able to answer next. I believe Mr. Fortin is having some power troubles and will not be able to, but if he reconnects, so we'll give him his time afterwards. So I'm going to skip and go over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, for keeping me on my toes. I want to start just by asking a question about the number of mandatory minimum penalties that will remain on the books after C5 passes, and if you have a figure of those. My recollections were probably around 73 or 75 existing mandatory minimums, something like that.
There are currently 67 offenses in the criminal code that are punishable by a mandatory minimum penalty. 13 of those relate to firearms will be repealed by this bill. One of them will be repealed in relation to a tobacco-related offense. So that would be 67 minus the 14 in the criminal code. And with respect to the Controlled Drugs and Substances Act, they will all be removed. There are currently 6 offenses that are punishable by an MMP in the Controlled Drugs and Substances Act.
So that means there will be something, well, I guess my math is always, never do math in public is one of my rules, but about 40 mandatory minimums that would remain. We got 3 different numbers on the other side. So 47, okay. How many of those are currently subject to appeals in the court system? You may not have that. I know our court system is quite decentralized, but I know that a lot of these are regularly challenged on constitutional grounds. Do we have any idea of how many of those cases are taking place now?
So as of March 30th, 2022, the Department of Justice was tracking 245 charter challenges to MMPs. This represents 35% of all charter challenges to the criminal code that are being tracked by the department. There are 27 challenges to MMPs for firearm offenses, 7 at the appellate court level and 20 at the trial court level. There are also 2 challenges to MMPs for drug offenses, including trafficking, import, export, and production, and both of those are at the trial level. Of all cases that were tracked by Justice Canada in the last decade and where the decision was rendered, 69% of the charter challenges to MMPs for drug offenses were successful. Almost half of the charter challenges to MMPs for firearm offenses were successful, 48%.
And the reason I ask these questions is I'm one of those people that would like to see the court spend its time on the more serious crimes that are more serious violent crimes that really threaten the communities. And so from what you're telling me now, if we do pass C5, we will take a significant number of future challenges out of the court system completely.
Indeed, one of the trends that we've seen over the last maybe over 10 years has been that mandatory minimum penalties have, as the minister said, increased the number of successful charter challenges, reduced the number of guilty pleas, which often require victims to testify more often in certain cases, and also sometimes also increased the amount of imprisonment of shorter duration at the expense of sometimes more effective and longer community-based sentences. So by repealing these mandatory minimum penalties, these resources can be redirected towards measures that are more effective and will promote lowering recidivism rates.
Thank you for that. I think it's an important point to remember when we're considering this, that there are not only costs but also savings from removing the mandatory minimums. We might get better outcomes for a cheaper price when it comes to the court system. I want to switch and ask a question, a concern I have about increased discretion for the police in this bill in the absence of serious reform with regard to systemic racism in the police. I know the Justice Department's not responsible for that, but there are 2 provisions in the bill where I'm concerned that in the absence of that reform, there aren't safeguards to prevent systemic racism from continuing to operate. The first of those is allowing police additional powers of discretion at the initial level of contact. And so my concern is that we've seen too many police forces where that discretion will benefit the white upper middle class people who come in contact with police and not racialized and Indigenous Canadians. And the second place has to do with record keeping. And the bill in C5 says that the police may keep records. And so again, my concern in the absence of police reform is that those records will be kept on Indigenous and racialized Canadians and will not be kept on others who come on contact with the police. So I wonder if the department has any comment on my concern about police discretion and record-keeping discretion in the absence of that serious police reform.
So what I can say about record keeping is that the purpose of the section is to allow police officers to keep records of warnings and referrals so as to avoid confusion by police officers and ensure consistent application of the provisions. These records are inadmissible in the bill. It's indicated that they're inadmissible for the purpose of providing prior offending behavior in any court proceeding. I can also say that the bill provides an overlapping system of checks and balances where the police officer fails to exercise their discretion at the first point of contact and refers that matter, lays the charges and refers it to the Crown. The Crown is obligated to follow the principles that are laid in the Controlled Drugs and Substances Act, but also prosecutorial guidelines, which exist at the federal level and at the provincial level, and which essentially say that the criminal charges should be kept for the most serious drug offenses that endanger public safety.
Thank you. Thank you, Mr. Garrison. Now over to you, Mr. Brock, for 5 minutes, please. Oh, Mr. Fortin's back. Sorry. Mr. Fortin, glad that you have your power back. Your round was skipped. I'm going to give it back to you for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. I'm sorry that I got disconnected. We've heard the minister earlier say that the first reason why this bill is being tabled is to fight against systemic racism and the overrepresentation of racialized people within our prisons. Has there been a review on the reasons why racialized people are overrepresented in our jails? Is it because they commit more crimes? I imagine that's not necessarily the case. Would it be because police officers are more strict? Is it because judges are more strict? Is it because there are not enough legal support services in these communities? Maybe there's other reasons. Has someone done an assessment of this? And could you tell me what explains this overrepresentation of racialized people in our correctional services? This is a very complex issue. What we do know is that we have data that demonstrates that some delinquents, including Indigenous people, marginalized people, and Black people are overrepresented with regards to some offenses. Some offenses, for example, offenses linked to firearms, drugs, and they're overrepresented in the criminal justice system with regards to offenses linked to MMPs. Now, to answer your question, the reasons are extremely complex and go further than C5. So isn't it not surprising that the Department of Justice is reacting by saying, we're going to eliminate mandatory minimum sentences? But if I understand your answer, the reason why there's an overrepresentation of racialized people in our prisons has probably nothing to do with the issue of MMPs. We know that through many studies that MMPs do have a differential and negative impact on these communities, on racialized communities. So there is evidence that demonstrates that when discretionary power is removed from the judge, there are procedural fairness issues that arise, making it so that these people are found in the criminal justice system more often. Strategic investments have been made to combat this. Investments were made in community centers, in community justice centers, rather. We know that the government also has, the Supreme Court implemented GLADU. When a member of an Indigenous community is accused, inaudible. People who work in the field tell me that there's not enough resources in Indigenous communities to prepare GLADU reports. Judges are asking for this, but defense lawyers say, well, I'm sorry, but I don't have anyone to prepare this type of report. Would this have not been a better way to tackle this issue of overrepresentation of Indigenous peoples, for example, in our prisons? I'll answer in English if you'll allow me.
In fact, the government has made several investments in Budget 2021 and the Fall Economic Statement, which support GLADU writing at sentencing, and that the same thing goes with respect to impact of race and cultural assessments. They assist the judge in considering the disadvantages and systemic racism that have contributed to racialized Canadians' interaction with the criminal justice system.
Manifestement, il semble qu'il n'y en a pas encore suffisamment, mais...
So it seems that we don't have enough, but I have another question, if you'll allow me. I'd like to come back to what the minister was saying. If one discharges a firearm with intent, the minister was saying if someone shoots into an empty wall because they are inebriated or whatever reason, it's not necessary to incarcerate this person. Possibly, I might agree. But I told the minister that perhaps if this offense had been divided so that if someone is discharging a firearm with intent on a person would be treated differently than someone who is discharging a firearm on an inanimate object, would it be possible to divide up this offense, that it will be dealt with differently depending on the intent?
L'infraction en tant que telle.
Well, the offense is determined by the courts, and it's quite broad. That means that it can be committed in different circumstances, and when the sentence is determined, when there's a mandatory minimum sentence that is applied, the judge cannot necessarily take into account all the circumstances. If they wanted to impose less than the mandatory minimum sentence, and as we see in one of the Supreme Court decisions, one of the ways to rectify this with regards to MMPs and the constitutionality of them is to reduce the scope of the offense. Yes, but don't you agree with me? If someone...
Out of time, unfortunately. Mr. Brock, over to you for 5 minutes.
Thank you, Chair. And to all the participants, thank you for your attendance. I will not be asking questions specific to anybody. Anybody can respond. So the first point I want to address is the latter points from my colleague, Mr. Garrison, who left the committee with the impression that there is some benefits to passing Bill C-5 because there's going to be an ultimate savings to the criminal justice system, A, in terms of costs, and B, in terms of expediency. Well, I can explain, and hopefully the panelists will also agree with me, that that is a complete fallacy. The fallacy is eliminating mandatory minimum penalties will not decrease substantially the amount of charter litigation. As a member of the Ontario Bar and who's prosecuted the Ontario courts for the better part of 30 years, I can inform you that there are charter challenges for just about every offense in the criminal code. It's not necessarily confined necessarily to gun offenses. Is the department prepared to acknowledge that there will not be a direct correlation, a substantial correlation in the reduction of charter litigation if we eliminate these 14 mandatory minimums? Yes or no?
From what I understand, the trends over the last 10 years or so demonstrate that the enactment of these mandatory minimum penalties have contributed to an increase in charter challenges.
And Mr. Chair, if I might add, in 2016, federal, provincial, territorial ministers responsible for justice determined, as part of their deliberations over how to address the Supreme Court of Canada's decision in Jordan and to find efficiencies to address and prevent delays. There was agreement at that time that one of the important measures that could be advanced that would help address the issue of delays more generally would be to address mandatory minimum penalties. So in general terms, I think there is certainly an expectation, and as my colleague has outlined, we are tracking quite a number of offenses that have moved, charter challenges that have moved in this direction. So we hope to see some of the benefits coming from this down the road. And of course, we will work with our existing federal, provincial, territorial counterparts to monitor and assess the impacts of the amendments if Parliament...
Thank you, Ms. Morency. I want to move on now. I want to address the whole concept of still maintaining the 14 mandatory minimums, but putting into place a constitutional exemption that would give the flexibility to judges across this country to exempt the outliers for whom the mandatory minimums would constitute cruel and unusual punishment. Did the departments consider this? And if so, why has it been rejected in the form of the draft bill?
I can try and answer that. As the minister said, he did look at a number of options with respect to addressing the negative impacts that my colleague has discussed on mandatory minimum penalties. His decision was that the approach proposed in Bill C-5 was achievable, something contained and that could move in the short term.
Thank you. I want to move on now to conditional sentences. I think we all agree that it is a condition precedent within the code itself that a justice must be satisfied that serving a sentence at home would not endanger the safety of the community. We also have Section 752 in the criminal code, which is completely absent in Bill C-5. And Section 752 defines what a serious personal injury offense is. And a serious personal injury offense can be any indictable offense involving the use or attempted use of violence against another person or conduct endangering or likely to endanger the life or safety of another person, or inflicting or likely to inflict severe psychological damage on another person. In my opinion, the offenses of sexual assault, criminal harassment, kidnapping, human trafficking, arson, and abduction of a person under 14, which now, pursuant to Bill C-5, makes conditional sentences available, would run contrary to Section 752, which would then increase the amount of litigation within the courts. Has the committee, has the department considered the impact of Section 752? Because judges across this land have consistently ruled, particularly at the appellate level, that anytime you have a serious personal injury offense, the whole concept of a conditional sentence does not qualify.
Mr. Brock, you're out of time, but I'll give Mr. Mano a few seconds if he has a quick answer.
What I can say is that under Bill C-5, there's certain conditions that would be required for a CSO to be imposed. The first one being a sentence of less than 2 years that respects public safety, that is consistent with the purpose and principles of sentencing, that is not an offense of advocating genocide, torture, attempted murder, or a terrorism or criminal organization offense of 10 years prosecuted by indictment or more. 10 or more years prosecuted by indictment, sorry.
Thank you, Mr. Brock. Over to you, Mr. Zaberi, for 5 minutes.
Thank you, Mr. Chair, and thank you to the witnesses for being here. I wanted to continue on the theme of CSOs or conditional sentence orders. And we did hear the minister explain them. We just had a series of questions on them. I'd like to open up the floor for more elaboration, if you would please, around how CSOs would actually work in practice and how often are they currently imposed.
So we've seen with the enactment in the last 10 years of further restrictions on CSOs, a diminishment in their being ordered because they weren't available for as many cases. Community-based sentences like CSOs tend to like according to Statistics Canada, data shows that in 2019-2020, CSOs were imposed in 6,720 cases across Canada. And by contrast, in 2004-2005, prior to the reforms that restricted their availability, CSOs were imposed in 11,545 cases across Canada. The purpose of a CSO, as the Supreme Court of Canada has noted in R.V. Proulx, is really a sentence which can have two components to it. It can have a punitive aspect to it, which involves strict punitive conditions like house arrest, curfew, prohibitions on owning of firearms, which all go to the public safety component of the sentence, but also rehabilitative aspects and components of it that go to restorative justice. And by imposing these sentences in appropriate cases, it shows that you can get significant reductions in recidivism. Imprisonment in the wrong cases can sometimes strengthen gang affiliation and actually contribute to stigmatization that actually endangers public safety.
Certainly, and you really touched upon at the end a point I'd like to elaborate on further. I'd like you to elaborate on, I should say, further, which is I'm curious, has there been any research done in terms of the impacts of utilizing CSOs effectively and how that bears better results than minimum mandatory MMPs? Has there been any research done, and if so, can you share that with us?
We do have a bibliography of research that we'd be happy to provide to the committee.
I think it'd be really interesting because if you take, for example, somebody who is addicted to opioids, right? I would suggest that CSOs would be better than MMPs to help this person to get back on their feet and fully contribute to society in the way that they probably would like to do. But can you share any insights about how CSOs would be better than MMPs for people, for example, who are addicted to opioids or other drugs?
Well, one of the contributing causes of the opioid crisis is exactly stigmatization. And several studies demonstrate that the over-reliance on incarceration is actually associated with an increase in reoffending and produces particularly negative effects on lower risk offenders. Moreover, studies show that recidivism rates for CSOs have actually been relatively low. CSOs are effective in appropriate circumstances because they provide offenders with the ability to access treatment and to continue their employment while simultaneously decreasing incarceration rates.
So can we talk in the minute that's left a bit about the minutia of how conditional sentence orders work? The Justice Minister gave us some examples. Can you elaborate a few other examples for the understanding of our committee?
A community-based sentence like a CSO will be imposed where the judge is of the opinion that a sentence of less than 2 years is appropriate. What's particularly effective about this sanction is that it can be coupled with mandatory treatment. When a person serves a sentence of imprisonment, the judge cannot order that offender to undergo treatment. Therefore, attacking the sentence is really one that allows the court to help the offender attack the root causes of offending. And when you attack those causes, you get significant reductions in recidivism.
100%. Thank you.
Thank you, Mr. Zuberi. Next, for 2.5 minutes, Monsieur Fortin, please.
Merci, merci, Monsieur.
Thank you. I'd like to come back with Mr. DiManno and come back to where we left off. In your opinion, Mr. DiManno, discharging a firearm intentionally in the direction of a person, should this not merit a sentence, a prison sentence in each case? I'm talking about intentional discharging of a firearm towards a person. In your opinion, are there any situations where this should not merit imprisonment? Well, what I can tell you is that in the circumstances, the offense could be even broader. It's up to the court to determine the appropriate sentence in these circumstances. Bill C-5 does keep MMPs of 5 years and 7 years when a prohibited firearm or restricted firearm is used, and also when the offense is linked to organized crime. Yes, but we're talking about 244(2)B of the Criminal Code. MMPs, 4 years for discharging a firearm with intent. The minister was saying earlier, well, if you fire into a wall, maybe you shouldn't go to jail. Okay, I agree with that, and I concede that, but I'm saying that if you intentionally fire in the direction of a person or several people, should this not merit a jail sentence? The trial judge will look at the circumstances of the offense, and when a crime is committed with the use of a firearm, and if public safety is in danger, the principles used by the court are very specific. Yes, I agree with you, Mr. DiManno, but the judge will surely impose a jail sentence. But my issue is that with C5, a message is sent out to the population. It says, we legislators, we don't find that to be particularly serious. We think that we can take out MMPs, and that's my issue. I am convinced that in a situation, a judge will absolutely impose a jail sentence. They're not going to not if someone shot someone. But as legislators, we have a responsibility, and I find that this message is not very clear.
Next, Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I too kind of want to go back to where I was at the last time, but I do have to say, since Mr. Brock made a comment about my position on this is not that we save money for efficiency reasons, but that we save court time and court money to apply it to the most serious offenses, which are the most threatening to the community, and we ensure that people aren't released because of court delays for very serious cases when we're taking up court time with what really are things I don't believe belong in the court system to start with. So it's not just about efficiency, it's about the use of our resources efficiently in the court system to better protect the community. Now, I'd rather be talking about decriminalizing personal possession of drugs, but we're not. So I want to talk about the discretion that's given, again, to police and prosecutors. That's where I left off. There doesn't seem to be a clear criteria set out in C5 for how that discretion by prosecutors and police would be applied. I think it's an increase in discretion for police. I'm not sure it's really an increase for prosecutors, but there don't seem to be clear criteria of how to apply that discretion.
It's not really an increase in discretion for police or prosecutors, Mr. Garrison. It's really an acknowledgement of the discretion that they already have, and the bill itself is seeking to nudge them to take these considerations, to use their discretion in a way that addresses the concerns in the bill. To go back to some of your earlier comments around concerns around the use of discretion, I mean, I think that's a concern that we've heard consistently with respect to the bill. I think it's something that the ministers acknowledged as well in terms of the importance of not just proposing legislative reforms, but looking at those other larger systemic issues. The government's commitment, for example, to an Indigenous justice strategy, a Black justice strategy, very much looking at those broader systemic issues. But of course, legislation in and of itself and federal government on their own can't address these larger issues.
There doesn't seem to be a requirement in C5 to keep any record of the use of that discretion. So I'm wondering how, if we're going to check on whether that's being used fairly and whether we're meeting the goals of anti-racism, if we don't keep any records at all about the use of that discretion, how will we know that that's being effective?
I mean, I think it's a good question, and the use of discretion in the criminal justice system exists already in terms of the ability to dig into the improper use of discretion. There are recourse available in the context of prosecutorial discretion, abuse of process, complaints to police bodies, things of that nature. But you're right, the bill itself doesn't speak to that issue.
Thank you. Thank you, Mr. Garrison. The last 5-minute round will go to Mr. Moore, and then we just have some budget issues right after. Thank you, Mr. Moore.
Thank you, Mr. Chair, and thank you to our witnesses for appearing today on what I think is an important bill. There's a myth that's perpetuated out there, and I want you to quickly confirm something. We've heard many of these mandatory minimums referred to as Harper-era mandatory minimums, and while it's true that under the Safe Communities Act, the Conservative government removed the application of conditional sentences for such crimes as arson, trafficking in person for material benefit, sexual assault, and criminal harassment. I want to speak specifically on the mandatory minimum penalties for gun crime. I'm going to list some of them. Using a firearm in the commission of an offense, possession of a prohibited or restricted firearm with ammunition, possession of a weapon by commission of offense, possession for purpose of weapons trafficking, robbery with a firearm, extortion with a firearm, discharging firearm with intent. I know you're all familiar with those provisions, but could you confirm for the committee that all of those mandatory minimums that were put in place predated the previous Conservative government and were in fact brought in by Liberal governments?
I think we'd have to confirm the list with you, Mr. Moritz. Certainly, there were a number of firearms MMPs that predate the previous administration. As you likely recall, a number of those MMPs were increased during that period of time. The 5 and 7 year MMPs, for example, involving prohibited restricted firearms or organized crime. But we'd have to circle back. Yeah.
Yeah, and if you could do that and provide it to the committee. I mean, I've taken the liberty of checking on all those. I can confirm that they were all brought in by previous Liberal governments. However, if you could confirm that and get back to the committee, I would appreciate it. I don't expect the other members to take my word for it, but they'll take your word for it. Looking at some of the, I'm a little alarmed to hear that there was no specific consultation. I heard about polling on mandatory minimum penalties, but specific consultation on specific groups who are more likely to be victims of criminals than others, and their feelings about response to what's being proposed in Bill C-5. Just quickly, Statistics Canada reports that those who identify as lesbian, gay, or bisexual are at greater risk of being violently victimized. Now, this legislation, and I had asked the minister about its impact on women, but this legislation provides for conditional sentences for some serious crimes, as well as the removal of mandatory minimums. Was there specific consultation with various communities on how they would be impacted from a perspective of a victim if this legislation passes?
I think just to maybe elaborate on what Mr. Domano had said earlier, the government had done fairly extensive consultations on the ideas, the areas of reform that are reflected in Bill C-5, and I'd point you to the Justice Canada website. There's a publication there that summarizes the consultations that they did on the criminal justice system review, the roundtables that were held by the Minister of Justice and Parliamentary Secretary. So yes, there was fairly extensive consultation and input sought on issues like conditional sentences, on mandatory minimum penalties. The earlier point was, were those groups consulted specifically on the reforms as drafted in the bill, and they were not. So, and just
yeah,
to,
thank you. Go ahead. Well, Mr. Taylor, I thank you for that. I guess that concerns me because we're talking about different identified groups, we're talking about First Nations, we're Indigenous, we're talking about a Black community, we're talking about lesbian, gay, bisexual, and what we find out is these communities were not consulted, even though they are more likely to be the victims of the very crimes that this government's going soft on in this legislation. So that's obviously concerning, and we'll be bringing forward witnesses at committee to further explore that.
Thank you, Mr. Moore. We're out of time. I want to thank you. No problem. Thank you, Mr. Moore, and I want to thank all the witnesses for your very valuable testimony and your time today. I want to thank all the members today as well. We just have a brief budget matter. I think we have to approve the budget of this report. So witnesses, by the way, you're dismissed. You're more than welcome to leave if you would like, but you can stay on and listen as well. I believe you've all been received the budget. I just also want to warn the budget may have to change as there's been a new House decision. I believe that in-person witnesses after we come back from the break are permitted, so budgets may have to be changed to adjust for travel and accommodation for them. So keep that in mind. But are we all in favor on the budget?
Yes.
I see thumbs up. Everybody in the room as well. So thank you all in favor. It's passed. Please have a great weekend and constituency break, and we'll see you back when the House resumes.